Welcome to the In-Rem podcast, where we discuss the law for real estate investors. Andy and Sean are both attorneys. Nothing said in this discussion should be considered legal advice. We're simply providing information and education. You should consult with an attorney in your state regarding any specific legal issue that you may have. Hey, everybody. Good morning. Thanks for joining the show today. We appreciate you being here with us today. Our topic is how contested probates impact the sale of real estate. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, or if you're old to the show, give us a like. We're on Facebook and YouTube. You can go right to our YouTube channel, click subscribe, follow. We would greatly appreciate it. With that, we're going to go to Sean, if you'd give us our legal update.
Yeah, so our legal update today is more Arizona specific, and it's dealing with a specific clause that is left out of a lot of contracts here in Arizona, and it's the septic inspection clause. And what I mean by that is not every property here in Arizona has a septic. Generally, when you're dealing with property on, county islands or even properties outside of Maricopa County, a lot of them are going to have septics. And so you want to deal with that because in Arizona, you have to have your septic pass an environmental and working conditions inspection within 6 months prior to closing. So if you've had it inspected 2 years ago and it passed and everything's functioning well, when you go to sell your house, you have to have that septic inspected and have a report from a proper licensed inspector that states that the septic's in full working order and fully complies with Arizona law. And if you don't receive that certification, you can't close. Arizona law prohibits closing, and so title companies are not going to close. So what happens is investors or even just parties that are represented by realtors, but they don't realize that it's on a septic or otherwise, or it's not, the issue's not spotted, and they enter into a contract and the contract doesn't say anything about septic, doesn't have an inspection clause or anything like that. They deliver the contract to title and they're going through the process to close, and title says, "Oh, where's our septic certification?" And they say, "What's that?" "Oh, well, that's," and they, educate the parties on what that is. And so then the question is, who's going to pay for that inspection, right? So the buyer and seller are sitting there looking at each other like, "Well, I don't want to pay. Well, I don't want to pay." So somebody has to pay for the inspection. Then if it doesn't pass, who's going to pay for the repairs? And so once again, the parties are looking at each other saying, "Well, I don't want to pay for it. I don't want to pay for it." But yet you can't close until those repairs are made. So it's important to have that clause in there if the property's on septic, which basically, and you can allocate the payment of the inspection, the payment of repairs to the different parties in the transaction, but it specifies who's going to pay for the inspection. Normally the seller would pay for the inspection, but the buyer can choose to pay for it. Who's going to pay for the inspection? And then what happens if it doesn't pass? Normally, if the repairs are like $1,000 or $1,500, the clause would say that seller fix it in that case. But if it's over that, then the buyer can choose to make up the difference and close, or the buyer can cancel, but the seller's not obligated to repair. That's kind of standard. But you could say, well, the buyer's going to pay for all the repairs up to a certain amount. And then after that, the buyer can either choose to make those repairs or cancel the contract or something like that. So you can decide who pays for what. But if it's not in there, then it's kind of, a game of chicken, almost like, well, who's going to pay for it? We can't close. And now we're kind of stymied and we need to do something with the transaction. So it's good to set that forth and document that at the very beginning of the transaction, so you don't have issues later on.
Well, it's a lot more common than you would think, right? Because, we're here in Maricopa County, which is a large county. You've got Phoenix and Scottsdale, Chandler, Mesa, all these large cities, and your thought is, well, they're all on city. This isn't going to be a big deal. But there's tons of county islands where it seems like it's just commonplace to find a septic, and so makes a lot of sense. Thank you, Sean, for that legal update. With that, we're going to get right into our topic today. So our topic again is how contested probates impact the sale of real estate. Now, we've gone in other episodes just in talking about how the probate process can and does impact real estate, and it does. But contested probates even more. And with us to discuss our topic today is Dustin Schanaker. Dustin, thanks so much for being with us.
Of course, thanks for having me.
Dustin is an attorney with Fowler St. Clair. He manages the Fowler St. Clair's Casa Grande office here in Arizona. Dustin, tell us about your practice, how you became involved in probate matters.
It was one of those things that kind of just fell in my lap. When I first joined the firm, I kind of just took an interest to that. Also the estate planning, where it's, let's plan to pass our assets on to our heirs before we die. Then, the probate side is dealing with what happens with those assets when it hasn't planned properly. And so, yeah, it's kind of all about planning and then dealing with the consequences of failing to plan. And that's something that I'm interested in and like doing.
So kind of at the beginning of this discussion, we'll work into contests and what that looks like. But let's set the stage here and give the listener an idea about the types of probate that the real estate investor here should expect to see. The
Sure.
different types of probate, from we've heard of affidavits to these formal contested ones. So what kind of possibilities would the real estate investor be looking at?
Yeah, it's kind of a spectrum. On one end you have the formal probate, and that's where we've got some problem that's going to require the court to get involved and oversee to some extent, whether it's litigating, is this will even valid, or maybe they've lost the will, and so we have a photocopy, or it's a handwritten will, and so again, the court has to weigh some sort of evidence to then make a determination of, you're the proper party, you're the proper heir, or yes, this document is valid or invalid. That's kind of one end of the spectrum. That takes a while and it costs a lot. The other end of the spectrum is the affidavit. Other states call it, in Arizona, we have the smallest state affidavits, and so there's certain requirements, but because they are more strict on what those requirements are that you have to comply with, if you can check all the boxes, then the court allows you to transfer that property by affidavit. And so this process is obviously the cheapest and quickest way to get the property transferred to the rightful party. And then kind of in between there, we have an informal probate where we might not be able to check the boxes for the affidavit. Either the estate value is too high, or it hasn't been long enough since the person passed away. But we're not in that formal context where the court has to be involved and have hearings and stuff like that. And so you file the paperwork, and the probate registrar will approve that, which then allows you to sell the property.
Now, just taking off on the affidavit context, because I imagine this is where a lot of the real estate investors see this, is they look for a quick fix on Google. How can I fix this issue that's popped up? And something comes up about an affidavit, and that's a quick, cheap, easy way to do it. How quickly, realistically, can a property be sold using an affidavit if it's appropriate?
Yeah, so from start to finish, in theory, it could be done in a matter of days. From the time a client comes to me, gives me all the information that I need for drafting that affidavit, put it together, we file it. And in Maricopa County, the probate registrar will approve that usually within a day, sometimes 2 days if they're real busy. I live in Pinal County, which is Florence, Casa Grande, Maricopa, so I can kind of talk a little bad about it. We're slow in Pinal County. So if you're looking in properties in those kind of outlying areas around the Phoenix area in Pinal, that takes longer. I've had documents that in Maricopa would be approved in a day, and I've had it sitting with the Pinal County clerk for up to 40 days. And so whenever I have an investor who's trying to get this process done so that they can close by affidavit, if it's in Pinal County, I'm telling them you're going to have to wait. Not always. Sometimes they will get it done, but it can be a while down there.
So the process from your perspective is relatively easy in that,
Correct.
you're able to prepare that. What does it look like? And it's one thing for you to prepare it. It's another thing to qualify or
Right.
to be eligible to use it. So as easy as that sounds, and as great as that sounds, what's the barrier to entry to be
Yeah.
able to utilize that?
Yeah, I mentioned that strict kind of checklist. So you have to wait 6 months from the date that the person passed away. So if the owner that's on title of record, if they pass away January 1st, you've got to wait 6 months from January 1st before you can go file your affidavit. The equity, there's a whole wording for it, and I'll skip the legalese, but basically the equity in that property has to be $100 for the decedent's interest. So they own it with another person. You're only looking at half of that. The small estate, right? We're looking at these property of small value. And then there's other things dealing with creditors and liens and stuff like that. But those are really the two big ones: is has it been long enough? Has it been more than 6 months since they died? And are we under that threshold for the value of the property?
So for a real estate investor, 6 months is, a universe of time. I mean, that's forever, right?
Right.
So, and it appears from what you're saying, especially with the small estate affidavit, given its name, that it's really a process designed to help facilitate small estates
Right.
in being able to move their assets. Let's say you qualified for that, but you just don't have 6 months to wait. The market's moving. Maybe the market's moving up. Maybe it's moving down, but it's moving. What alternative do you have at that point?
Yeah, then at that point, we move kind of up to that informal probate. There's no time waiting requirement for an informal probate. And so
Like no time from the date the deceased
correct,
dies?
you could, I think technically it's like 120 hours, but basically, yeah, from the time an investor is going to be seeing this property, yeah, there you can file an informal probate basically immediately.
So I guess in comparing the two, you're able to file the paperwork and start the process much earlier. As a practical matter, does it take a lot more time for your office to prepare informal paperwork?
Yeah, well, to prepare it, not really to get the first phase done. The difference here is an affidavit signed by the heirs gets filed and approved, and it gets recorded. And that effectively transfers title to those heirs. Whoever signed that affidavit, they now are the owners of record. With an informal, so then at that point, now they're the ones that will be selling and closing on the sale. With an informal probate, that initial time frame is essentially the same. You prepare it, you file it, the probate registrar will approve it within a day or two, and the property is still owned now by the estate. And so the difference there is, sure, the personal representative, whoever that person is, they can now sign the closing document. So from the investor's perspective, great, they can now close within a matter of days from that person being appointed. The back end then has me and the personal representative having a friendly relationship for the next 6 months or so while we're dealing with creditors, and we've got to inventory assets and circulate accountings and all that. So there's a lot more on the back end that you don't have to do with the affidavit.
So comparing that process, then jumping forward to what you mentioned earlier, the formal probate, as a practical matter, is when we'll get into situations where a formal probate might be required. But from the investor's perspective, who just wants to get this thing sold, and formal ends up being required, what's the time frame look like that as compared to affidavits and informal?
Yeah, the unfortunate thing there is just kind of on its own, a formal probate takes that time when you could close, and it bumps it out several months. With an informal, again, you're getting appointed right at the beginning and can close on the deal. With a formal probate, we have to have a hearing first, and so the kind of default way this happens is you file your petition outlining the arguments and whatnot, and then the court just sets you on their calendar. And so you're going to appear before a probate commissioner whenever they can get you on their calendar, which usually is between 6 to 8 weeks. And then that personal representative hopefully might be appointed at that point at the hearing, and then you can close. And so there's a problem there, right? You're not going to be able to close on this transaction as is until several months. And if there's people fighting, it's going to be even longer than that while they litigate the issues. So one thing that you can do in the context where we've got this pending formal probate and parties are fighting, it's going to be a while. You can file for special administrator, which is a kind of subcategory that the probate allows, where it appoints someone with authority to do something. And it depends on what you're needing done. Sometimes it's accepting service of a quiet title lawsuit. Sometimes it is, hey, we need to at least preserve these assets, and so give us the authority to now manage just these assets. But in this context, we would use a special administrator to get appointed for the purpose of signing the closing documents. One, so that we don't lose the buyer. Two, we don't want to then have to go back out and deal with the market and all that. And so the special administrator allows that investor to close right now and not lose out on the property. We have to file an emergency motion so that we, rather than having to wait for that hearing, we get that hearing heard right away. And so that's kind of the thing that gets us through that time period.
Yeah, I was going to ask is does the petition for a special administrator in and of itself get you accelerated notice before the court, or is it the filing of an emergency petition that gets you there faster in that case?
It's the emergency. Yeah. The formal petition for appointment of a special administrator in theory follows that same time frame as a formal probate would. And so we file that emergency motion to get that on the court's calendar right away. In fact, week and I had a hearing Friday morning. And so the thing that's the special administrator allows is, one, we don't have to follow the formal notice requirements for a probate of a personal representative getting appointed. So we just emailed the notice to all of the heirs, and they were able to receive that, and the court was okay with that because it was, again, for this limited purpose. Also, all of the things that the siblings were arguing about doesn't really matter because it is for such a limited purpose of, we just want to sell this property so that we don't lose out on the deal.
Hey, Dustin. So what are some things that will cause a probate to be formal? Because obviously the goal would be to be informal.
Right.
But what are the things that cause a probate to go that direction?
Humans. It often comes down to siblings. That's usually the context that I see. But it's usually people arguing. It's, mom told me that I could have this asset and you think that you get it. And so somebody will object and maybe even take something that was an informal probate. And as soon as somebody objects to that, now we're in that formal probate context. It could be there's an issue with the will. Maybe it's signed but not notarized, or it's handwritten. I mentioned that before. A handwritten will, a holographic will, can only be probated formally. And so for the investor, there's a few things that are really important and helpful in making sure you know what you're getting yourself into. And one of those is, okay, we see that title is owned by somebody who's deceased. And so we want to make sure we're talking to the heirs, right? Who are the kids? Who's the surviving spouse? And the first question that needs to be asked is, did this person have a will? Because if the will says that you're the personal representative, then you're the right person to be dealing with so that we can go get you appointed as personal representative, and now you can sell the property to us. If the will names some other person, well, it doesn't do me any good to talk to the child if the spouse is the personal representative named in the will. And so things like that. And again, if you're asking about the will and you see that it's entirely handwritten, buckle up, because it's going to be either you're going to have to wait a while, or it's going to get pricey. And so those are some of the things that you can kind of look out for right at the very beginning of when you're getting involved in these deals.
So, what about, and I've come across this before when I did some probate work, a copy of the will, right? You go and you clear out, dad's house after he passes away, and you're going through that process, and you come across a copy of the will and you think, oh, great, we're golden, right? He has a will. So we know what his wishes were. We know who he wants appointed. We know who the beneficiaries are. Let's go and do a probate and get this property sold. How do you utilize a copy of the will for a probate?
Yeah, it's unfortunately, it's that formal probate context again. It's kind of like a holographic will. The court wants to be the one making that decision via the judge that this photocopy is a true and accurate representation of the original, because somebody could easily have a photocopy of the will in which they've slipped another page, or used whiteout in the photocopy to remove certain paragraphs and all that. And so the judges want to be the one making that decision, not the clerk, the probate registrar who's seeing these documents.
I've got to think that's a pretty common
It is.
scenario, the copy of the will, because as often as I know, you probably tell your clients to keep their original,
Right.
Yeah,
Put it in the freezer, the safe, but people always lose them. In that context, it's simple. It's not a difficult proceeding. Very rarely is somebody actually more or less committing forgery on and fraud on a will document. But you have somebody who's familiar with maybe what the original will said, and they say, yeah, I did at one point see that original will. This photocopy looks the same. That's dad's handwriting. We all know that. You can see all the numbered pages are there. It's not difficult, but it still requires that process.
not a big deal. We'll get worked out, but it is a one no stop pass directly to formal probate, right? You miss your opportunity to go informal, which is just a check the box process to make sure your paperwork's correct in informal probate, right?
Right.
Because that's what you really ended up waiting a long time on, is the courts and their ability to hear the case.
Right.
What about disputes over the validity of the will? And this sounds to me really like fights,
Right.
disputes over who gets what.
Yeah. Those are always going to be a formal. Again, you can have an informal probate turn into a formal probate, and an example of that is, a will was probated. They had the original. It went through informal probate. Somebody was appointed as personal representative, and then now another party, the sibling or whoever, comes forward with another document that says, hey, that original will was revoked and now it's replaced by this one, and party one didn't know about it, and so now we have kind of competing wills. The other one is simply, I had one where it was a purported will in the handwriting of the decedent on a napkin, and because it was handwritten, we had to go through the formal probate anyway. But more importantly, the son was saying, that's not dad's handwriting. He's leaving everything he has to his neighbor. I don't think that's probably what dad wanted. And so we had to go through the formal probate and invalidate that handwritten will. So we had to hire handwriting experts and analyze the signatures and the handwriting and all that. And so those are the things that, on top of just getting your initial hearing down a couple months, you're in litigation. I mean, you're in any other type of civil litigation where we've got discovery, we have deadlines, we've got motion practice. And so it could take up to years for it to be ultimately resolved.
How does civil litigation work in the probate context? Because my understanding is probate's a lot like bankruptcy, where there's a lot of outlying legal issues that sometimes have to be resolved in order to administer the probate. And I think the probate court has jurisdiction over some of those disputes, but maybe not all of them. How does that generally work?
Yeah, the general rules. So probate has their own rules. It has its own rules of procedure that dictate how things happen. Outside of that, if it's not mentioned in those probate rules of procedure, then the civil rules control. And so in that sense, it's kind of the probate rules supplement what the civil rules and those procedures look like. And so there are things that can then be resolved in the probate court. So one of them that frequently happens is quiet title, right? There's maybe dad was on title, but there's some cloud on title from way back in the 70s that dad never fixed, and now he's deceased. So we can go into the probate, we can get the kids or whoever appointed as the personal representative, and then now on behalf of the estate, we go resolve that quiet title issue. So they do go hand in hand there, because you're right, to gather the assets of the estate, sometimes that takes some sort of civil litigation. You're not going to bring a wrongful death claim in the probate court, but when it comes to title to property, those are things that you can kind of hook in as a part of the probate itself.
Now, what I think is interesting in estate planning, oftentimes we're told, or we tell folks, if they want to avoid the probate process, consider doing a trust, hold their assets in a trust. And we've talked about that a few times, but the trust owns the real estate, or they happen to have a trust, is that there's not going to be, does that mean that they're going to be exempt from the probate process?
I wish. No, it never doesn't always practically guarantee that, because again, in that situation where there's wrongdoing on behalf of a trustee, or there's now some issue of, well, how do we interpret this paragraph? Or maybe I don't think that trust was valid. If it was drafted and signed under undue influence, maybe like a vulnerable adult that has capacity issues, something like that. Those are all now formal probates where we're going to have to determine in court the validity of those things. And so for the simple estate, yeah, a trust will, if everything goes smoothly, the trust will distribute the assets outside of that probate. But that doesn't stop or guarantee that problems don't arise.
How about disputes over title to assets? I think we've seen that at times, and I think people forget that just because or somebody dies and their estate begins, their assets and their liabilities don't end, and their ability to sue or be sued over their assets doesn't end as well. So how do you see that playing out?
Yeah, when it comes to again, the one of the primary jobs of that personal representative is to gather and protect the estate. And so that often means, what does it look like to gather? Well, that means we might need to go file a lawsuit. If there was, a promissory note out there on this, secured by a deed of trust, and the deceased was the one that was benefiting from that, well, we're going to have to figure out how we deal with that loan. It doesn't necessarily accelerate the loan just because they passed away, but that means now that if there's monthly payments on that promissory note, now the estate's going to be gathering those payments. And so, yeah, there are things that we're going to have to deal with, and some of those might take longer than others in order to get all of those assets into the, I always talk about buckets, but we want to get them into the estate bucket rather than sitting out there doing who knows what.
Because the first step, correct me if I'm wrong, the first step about probate is really just to identify the person who's legally going to step into the shoes of the deceased, right?
Right.
And that's a big part of it, of course. If you're a real estate investor and you're just trying to move real estate and you need somebody to sign on behalf of the deceased to the new owner, that can go a long way. But if there's title issues like we just talked about over the real estate in question, really the beginning is just the first step. Right. Now you've stepped in that person's shoes and you get to begin that process of winding down, which could be lengthy.
Yeah.
What about disputes? What kind of disputes have you seen over? And I guess maybe this could go to validity, they will as well, but just disputes over who's to receive the estate assets. Disputes maybe over the language in the trust or the will itself.
Right. Yeah, it always gets fun when you see a will or a trust that has multiple amendments, because now we're trying to figure out, okay, which of these 5 amendments is controlling the actual distribution of assets, and so an amendment is going to say, I hereby revoke this paragraph and replace it with the following. Um, Not everybody drafts them perfectly, and so sometimes you might get some inconsistencies. Sometimes they change their mind all the time, and so we're just constantly changing who's getting the assets. And so that's when you see disputes is, well, I think that this paragraph leaves it to me. Well, I think this amendment actually changed that to me. So that might be one, is which document controls. The other one that our office has been involved in was where the property was owned by the trust, and the trust made a distribution of that property to a beneficiary. Well, the trustor sold that property prior to their death. So then the question becomes, okay, does that beneficiary receive the money, or is that entire thing stricken? And depending on the wording of that gift in the will or the trust, it's going to depend.
So how does that, for the real estate investor, how does that procedurally play out? In the will context, you had to go open up the probate, so you're already there.
Mhm.
But, let's say, given your hypothetical, you've got the trust situation. You're like, oh, this is awesome. We're not in probate. We're winding this sucker down with a trustee. And then all of a sudden, somebody finds a clause in the trust that maybe wasn't well drafted, or maybe it was perfectly drafted, but for whatever reason, everybody disagrees over the meaning. What does that look like procedurally? Does the trust now need to go in, start over from the beginning, and do a normal probate, or does the probate courts provide some sort of procedure for a trustee to go into court and get these kind of things resolved?
Yeah, the rules allow for a petition for instruction, because what you don't want to have happen is that trustee says, "Well, I interpret it this way, so I'm going to act that way," and now they distribute to the wrong person. Usually, the trustees are going to be more cautious than that, and so the court allows the trustee to petition them for instruction, and they will lay out in that petition, you know, I see that it could be argued this way. I see that it could be argued this way. In fact, I have parties arguing that way. I'm torn in the middle. I don't want to breach my fiduciary duty to any of them. So what do I do? And so we ask the court, here's the problem. Help us through this. And then there's going to be a hearing set on that. And um, then you kind of go from there. And the court will ultimately then provide instruction on that, so that you aren't now, as trustee, violating your duty.
All right, so that it allows the trustee to go in there and get their question answered,
Right.
basically,
Right.
so that the trustee has the comfort in knowing that whatever they do, they're just following what the court has ordered and
Right.
directed.
Right.
What about disputes? And I guess this could be over the personal representative or trustee, whatever the context is. What about disputes over their conduct? Because we know that they're in a fiduciary relationship. They owe fiduciary duties to the beneficiaries. What does look, and where do you commonly see?
Oh, these ones are fun. So I had a case where um, the person had passed away, and his caregiver had convinced him to change the trustee to be that caregiver. And so now this caregiver, um, even while the deceased person, before he had died, the caregiver was now managing assets. And then after the deceased died, he was still managing the assets. And so um, the conduct question is, it's now several years later, and the beneficiaries are saying, what's going on? We haven't received notices. We haven't gotten any accountings or inventories. What's happening? And the gentleman, the trustee caregiver, um, kind of just kept deflecting and not providing information. So I helped those beneficiaries go bring something in the court to say, we need an accounting. We want to know what's going on. And in that process, we discovered that the caregiver had a gambling problem. And so he had liquidated properties, he had liquidated accounts, and just on his own dime, well, not his own dime, the trust's dime, gone and had some fun at the slots and just lost $500,000. I mean, it was not a small amount.
Wow.
And so these beneficiaries are saying, well, that's our money. And so we had to go and get that person removed, obviously, so they didn't waste any more. And then, proceed with litigation to try to recover something. But yeah, you see conduct all the time. You see conduct where perhaps maybe they're liquidating the house and the trustee or the personal representative says, well, I want to buy that. They have a duty to go sell that at fair market value. They can't just go sell it to their brother and have them deed it back to him for, $1. And so there are things like that happen, though, where they think that they can get away with stuff. And now turns out we're having to go set transactions aside and try to claw back some money here.
Well, and obviously in cases like that, there's allegations of wrongdoing that are flying back and forth. And the courts in any of the systems, whether it's probate or civil court or criminal court, are going to afford all the parties due process, right? And an opportunity to be heard and defend themselves.
Right.
Which for the real estate investor probably means time.
Time, right.
Lots of time.
Yeah.
So let's, we've talked about some of the reasons that bring us into formal probate, and formal probate is really what lengthens out the period of time on this. So let's talk about how these impact closing. And we could start at the beginning. You offered one strategy in seeking a special administrator. Right. That sounded like a strategy where maybe there's a dispute over the appointment of who's going to be the personal representative, but the property maybe is going to be lost in a trustee sale or some other thing, and we need somebody here to just go sell it while we fight over that. Is that one area where that solution makes sense?
For sure, right? We've done that where we've gone up to the deadline of a foreclosure and been able to get that emergency petition approved and get the special administrator appointed, so that now we can request the payoff and get that paid out of the closing and actually sign the closing documents. Yeah.
As a practical matter, how hard is that to work out? Because you've got a series of parties who can't agree on who the personal representative is going to be. I would imagine they might have difficulty agreeing who might be the special administrator, or is there at least consensus at that point of, hey, look, all we're talking about here is selling this thing.
Right.
Then the money's just going to sit in the estate while the court makes its judgment. As a practical matter, is it usually easier to get agreement on the special administrator side?
It is, yeah. There's the carrot, that's waiting there, which is we've got this property, and everybody agrees that we want this property sold at the the highest value possible. And if there's going to be a foreclosure coming up, nobody's really going to get anything. So everyone kind of at that point, despite whatever their differences and arguments are of that prevent us from doing a normal probate, usually everyone's going to agree we need to protect this property from foreclosing or losing the buyer or whatever that looks like. And so you can usually at least get some agreement there. And in fact, I had a hearing last week where it was for appointment of a special administrator, and the parties were not quite in agreement. They weren't quite understanding the issues and all that. And the judge did an excellent job of getting us to that point where, okay, can we all agree that this property needs to be sold so that we don't lose out? Yes. Okay. We do agree on that. Okay. Then can we at least remove our objections to this petition so that we can sell? Okay. Yeah. So the judge did a great job of getting us there. So that everyone was at least in agreement to get this thing taken care of.
Hey, Dustin, I wanted to talk to you about settlement conferences in probate, because I will say, and you and I have both, represented clients at settlement conferences in probate. And one of the things that I found is if you can get these disputes into a settlement conference, that the probate court settlement conference process is probably, in my view, one of the best. And so talk to us about what that looks like. Why is it important, to try to get these cases into a settlement conference, and what makes the probate court so unique in resolving these issues in relation to maybe some other mediations or settlement conferences that our clients have on a regular basis?
I think there's a few things. So the process is when you're in that formal probate and you have the initial hearing, if somebody's objecting to the petition, then the court is going to say, okay, we can either just go straight down the litigation path and we're going to have deadlines and discovery, or we can refer this to a settlement conference judge. That is 100% always my preference, because I'd rather the heirs keep the money instead of paying me to litigate this thing, and now I'm the one that wins. And so I always try to push for, let's get a settlement conference. And it's essentially a free mediation, which is kind of nice. You don't have to go pay a private mediator. The court will assign either an actual judge, or they'll send it to someone on their list of judge pro tems that will mediate this at no cost to the parties. The thing to me that is so beneficial about this is, one, the judges are excellent. And I'm not just sucking up. I don't think any judges are proud of this. You never know. Maybe the judges, the probate judges that I have dealt with in settlement conferences, are the best. They will. I'm batting 1,000 here. Every single settlement conference that I have been to has resulted in a settlement. And that is usually because the judges are just great at kind of weeding through the emotions, because that's often what causes the conflict, right? Is these kids or whoever the relatives are fighting, because it's an emotional, right? Somebody's passed away. We're dealing with that loss and the grief, and now there's money at play that kind of just makes things worse. And so the judges are good at cutting through all of that emotion and pointing out, if we litigate this, it's going to take this much time. You're going to pay this much. You're going to pay this much. We're really only just disputing these things. Let's cut to the heart of the matter and find a resolution. I think the other thing that also helps is when we're dealing with like maybe a civil litigation matter that's at a mediation, you usually have one party alleging something against another that's going to result in some type of money judgment. And now that person has to pay it. So there's a lot of defense there, because it's like, well, I don't want to have to come up with 20 grand out of my own pocket to pay this judgment that's against me. And so people dig in and kind of fight. In probate, we have this pot of gold at the end of the tunnel. And so it allows us to kind of use that and say, look, nobody's asking you usually to pay money out of pocket. If we're all in agreement that we're all going to get 50 grand out of this, maybe the settlement ends up being, well, you get 60 and I get 40. And so it kind of, it makes it easier to reach resolutions, because it's not money that you don't have. It's money that you will have that we can use as leverage to reach a settlement.
So what kind of things will you do on the front end of a case that comes in where you're thinking, oh, we got to get this thing before a settlement conference judge? What will you start to do to try to make that process happen sooner rather than later?
I usually like, if I'm in a contested type probate, I usually like to start by sending a letter where I'm going to lay out all of the arguments. Here's the law. Here's the facts. I'm going to, throw everything in there to kind of set the stage and get as much leverage as I can. But then you end that letter with, look, here's what's going to happen if we end up fighting this. It's going to take this much time. You're probably going to hire an attorney. This person's already hired me. We're talking, 10, 20, 30 grand of attorney's fees to litigate this thing all the way through each. So instead of doing that, can we, here's our offer. And then I'll usually have the client give me a settlement offer that we can present to the other party. So we kind of set the stage from the beginning of, we want to be reasonable. We want to try to resolve this outside of court if we can. And sometimes that works. Sometimes you'll get them to sign, the waiver or set aside their arguments. But if they don't, and then we end up in the formal probate, now at least when we go to that settlement conference, we've kind of already set that tone of we're the reasonable ones. We already tried to settle this.
Realistically, assuming all of the parties are on board, they said, wow, that sounds great. Let's get this before a neutral third party that can help us kind of resolve this. If you had that situation and everybody was in full agreement, how fast realistically do you think you could get before the court?
It's kind of the same as getting a hearing. You're usually about 2 months out for a settlement conference to be set. Again, it's kind of just based on when those judges have availability. Oftentimes they're counting up, this day is Tuesdays are my settlement conference days. So it's just, when's the next Tuesday I get on there?
Now it sounds like the probate, because I know, at least my understanding is that the probate bench here in Arizona, they handle these conferences. The judges actually handle. So in some sense, the parties feel like, though it's not their day in court, they feel like they're getting it by
Right.
talking with the judge, which is nice.
Right.
And I see a lot of value to that. In civil court, you don't really have that. It's a little bit different of a process, and oftentimes we'll end up just doing it privately by hiring a private mediator. Is that really an option? Can that be done in probate courts, and is it done?
It can be done. To me, it's better to take the free option. Yeah, there's some time associated with that. You got to wait for the calendar to open up for it, but you're not having to pay the mediator themselves. Whereas if time is urgent and the parties at least agree, we need to get this done quickly, and so waiting for the settlement conference judge to be appointed is going to be too long. Then maybe the question is, okay, well, can we agree to this private mediator who hopefully will be able to get us in much sooner? But that comes with a cost. And so it can be done. My preference is, unless necessary, do the settlement conference judge because it's cheaper for the client.
So what this all boils down to for the real estate investors, how does this really truly impact our closing or our ability to close on this deal and get this done? And it really sounds like, well, it can impact closing in a lot of different ways, but it sounds like how it impacts it is largely going to depend on what kind of probate are you doing?
Right. There's a lot of facts and circumstances. I mean, every probate is different, right? Every case is different. And so you might even have similar title issues, but then, this one goes one way and this one goes another, just simply because the parties responded differently. So it is hard to really know how this is going to play out up front. You might think, oh yeah, all the siblings will make this easy. They'll all sign the documents we need them to sign so we can do the informal probate. And then lo and behold, they don't. And so for the investor, it is difficult. I'd love to just say, find the simple people. But you don't know. You can't talk to somebody and know right off the bat, yeah, this deal is going to be easy. It's going to be quick in the probate. We can close soon. You really don't know until you're in it.
Let's talk briefly about what happens. Let's say that there's a title dispute. I'll give you a hypothetical. Let's say that husband and they divorce.
Okay.
Judge awards the property to wife by the decree, but the decree doesn't have the magic language that we like to see in it to convey title, which is the legal description and actually awarding and titling the property in the name of the spouse, right? And unless it has that language, the decree doesn't do you any good, and a title company is not to insure it. Well, then the spouse that lost the title or was not awarded the property, they pass away.
Okay.
Now the decree is there, it's entered. Let's just say husband was awarded the property, wife's deceased. Well, the husband has a couple of options if the wife were alive, which is to go back into family court, amend the order, get all the magic language, record that order, certified, or quiet the title and say, hey, I was awarded this in divorce, and therefore civil court, make me the owner of the property, right? Well, now the wife's deceased, though.
Yeah.
So something has to happen. But husband is no longer would not be the personal representative because they're divorced. But let's just say wife, like nobody's cooperating. Like you're trying to get somebody to cooperate, on the wife's side of things, but they're not cooperating. There's no probate open. What do you have to do to effectuate a transfer of a property in that scenario?
Yeah, so there's a few components to it. So the first is we need to serve. If we're going down like the quiet title route, we have to serve her. Well, she's deceased. We can't do that. So then what's our next option? We need to serve her estate. There are ways of doing that. You can ask the court for alternative service, but there's complications with that. What's easier, and with my partner Brian is we kind of tag team it. I will go and do a special administrator for the purpose of accepting service of the lawsuit of the quiet title. So he'll handle the quiet title, but now we get that husband in your scenario appointed as the special administrator for that purpose of accepting service of the lawsuit. And so that allows him as a creditor, because that's ultimately what he is, right? He has a claim against the estate to fix the title issue that was never done the first go around. And so as creditor, he can get appointed as special administrator to accept that service. The benefit there is the notice that's required in the probate is different than notice that's required in a lawsuit. Lawsuit, you got to serve by personal service or some alternative service. In probate, what's required is regular U.S. mail or publication or personal service. And so in that case, we go and mail the notice to maybe the kids, her children, or her siblings that aren't cooperating. We mail them notice of our petition in the probate to get him appointed as the personal or the special administrator. If they have problems, they'll bring it there. And if they don't show up, then the judge is just going to grant the petition and appoint him. And now you can go resolve the quiet title issue in civil litigation.
So you're saying basically you appoint the husband as special administrator to accept service of process, and what's being served is the husband's own complaint.
Correct.
So the husband is accepting service of the husband's own complaint to the state.
Yep.
And that can be done.
It can be done. The special administrator has all of the, in a formal appointment, the special administrator has all the rights and powers of a personal representative, unless otherwise restricted by the court. And so we go in there and we say, this is all we're wanting to do. It needs to be done. No one else is willing to do it. We're left with no other remedy than to do it ourselves. And so we ask the court, give us that power. It's a power that the personal representative could do if one was there. And so, yeah, I mean, we've done it numerous times. Yep.
Very, very interesting. Dustin, we really appreciate your time with us and being here with us today. Where can our listeners find and connect with you?
Through the firm. We've got, call the main office line and set something up with me if you're interested. I'm on the Facebook investor page, and I'm fairly active on there as well.
So you can find Dustin on Facebook and the firm website, fowlerstclair.com. He'd be happy with those matters if you run into those issues. I know probate's a common problem for real estate investors. Thanks so much for joining us. We appreciate it.
Of course. Thanks for having me.
All right. With that, thank you for joining us. Next week our topic will be Navigating Troubled Waters. Part 2 is bankruptcy disrupting your real estate deal. We're talking bankruptcy with attorney Leonard Szymanski. Look forward to seeing you then. Have a good week.
Have a good day, everyone.